Although these examples of digital evidence are somewhat persuasive, they can only be obtained by the lawyer and the lawyer's staff and the client if we abide by important ethical rules. Clearly, we can never use deception or misrepresentation in any communication, including using an alias to friend an opposing party in order to get past their privacy settings. In fact, ABA Model Rule 4.1.1 talks about the duty of candor, and it prohibits making a false statement of material fact to a third party. Model Rule 4.3 also cautions us to be equally honest and forthright when the opposing party is not represented by legal counsel. In March 2009, the Philadelphia Bar Association issued an ethics opinion, and that opinion held that pretexting was dishonest, fraudulent, and deceptive. So do not advise, permit, or encourage anyone, your clients, staff, or even detectives, to use deception to gain access to an opposing party's profile. Much has also been written about authenticating information from the internet, from authenticating social media social media sites to websites. One of the very best cases that explains evidentiary issues concerning electronic evidence is Lorraine versus Markle. This is a 2007 case with its 101-page opinion by Federal Magistrate Judge Paul Grimm from Maryland has provided lawyers with much guidance in authenticating electronically stored information, and it also presents a myriad of circumstances, recognizing that technology changes so rapidly and is often so new to many judges that we must keep up with it and have an understanding of it in order to represent our clients to the best of our abilities. As Griffin versus Maryland, the case that I mentioned earlier, noted, and it also cited Lorraine versus Markle, Griffin versus Maryland quoted the fact that there are concerns that electronically stored information is often easily manipulated and therefore does require greater scrutiny of the foundational requirements as opposed to the foundational requirements required to introduce a letter or other paper to bolster its reliability. We all know that spoliation is the act of destroying evidence, and it was always much easier to demonstrate when a party had shredded documents or destroyed photographs. Today, the act of spoliation can also include deleting emails and other digitally stored information. Thus, preservation letters sent to the other side cautioning against spoliation are often a necessary part of our present-day discovery process and representation of clients. A recent personal injury case from Virginia is both instructive and alarming. The case was called Lester versus Allied Concrete. It's a 2011 case in which a prominent Virginia personal injury lawyer, and I do apologize, it says 2010, but it's actually a 2011 case. I believe the appeal was argued in 2010, but the opinion was not issued until 2011. But in this case, a prominent Virginia personal injury lawyer and senior partner at the firm of Allen, Allen received a sanction of $522,000. And while the sanction really arose more from the attorney's false statements to the court and the attorney's distorted representations and allegations that the opposing party had hacked into his client's Facebook account, the case does illustrate to all of us that there are inherent dangers regarding technology and social media, and we must fully understand social media and its use in the courtroom so we do not fall prey to these same problems. In addition, as most of us, hopefully all of us know, the ramifications of helping a client hide their mistake or our own hiding of mistakes has serious consequences not only to our reputation but to our career. And sadly, as I understand it, Mr. Murray is currently going through the process where he may be soon disbarred. Even the late-night comedian Craig Ferguson has commented, Andy Warhol said that in the future everyone will be famous for 15 minutes. Facebook is exactly like that, except you're not really famous and your 15 minutes goes on forever. So be smart. Do not tell any client to clean up or delete his or her Facebook page. And certainly do not help a client destroy evidence or help hide any other mistakes a client has made. As far as best practices, caution your clients to treat digital data very carefully. Advise them that the opposing party and legal counsel is likely searching their name on the internet, likely searching your name too. Help them set up appropriate privacy settings. Caution them to be prudent about what they share on the internet. Highly recommend to your clients they stop posting party pictures, that they stop commenting about all their daily activities, especially any activity that might reflect poorly upon them. Tell them not to talk negatively about their soon-to-be ex-spouse, and like the mother that I recently dealt with in the custody case, tell them never to speak poorly of their children at any time, and especially not on the internet in written format. And most importantly, again, advise your client not to delete or destroy evidence. Instead, with Facebook, advise your clients to deactivate their accounts. This is a very important tip. On Facebook, under Account Settings, Security, at the bottom where this red arrow points on the screen, you can see where it says deactivate your account. Deactivating an account only takes the account off the internet for whatever period of time you want to keep it deactivated, but it does not delete any information on your account. In fact, if you want to reactivate the account, you can reactivate it, and whatever was on there on the date and time that you took it down will be on there the date and time when you reactivate it. This is the safe way to help your clients not get into any trouble. Also, if the other side is successful in discovery and getting a court order to allow them to have any public postings from your client's Facebook page, if your client has deactivated the account, they can still download all their information and will not be accused of spoliation because all they did was take the account off the internet, but they did not destroy the information itself. Another very important setting on Facebook is, again, under privacy settings. And it's the setting that I pointed to where it says review posts friends tag you in before they appear on your timeline. Turning this setting on allows you to review any post before any post that your friends make about you before they go into your timeline. It also keeps your friends from posting pictures about you before they go into the timeline. There have been reported criminal cases where unflattering photos have been placed on one's Facebook page by friends that might help incriminate a criminal defendant, that the criminal defendant at least could have kept off their Facebook page had they had this setting, and they would not have been accused of spoliation. As mentioned earlier, in the next few months, the Technology Committee is going to upload a few more additional useful video presentations about Facebook, Twitter, and LinkedIn. These are going to be much shorter videos, about 10 to 15 minutes long. They'll help you set up your accounts. They'll help you do some basic activities on your accounts. They'll also show you how to gather information from others' accounts. And we'll even try to do a video about how to authenticate information from a social media site. The most important part of this whole series, however, will take place at our annual meeting in November. The culmination of our entire series will take place on Wednesday, November 7th in Chicago. There, with Ken Altshuler's vision and help, the Technology Committee is hosting a program called almost everything you want to know about legal technology but are afraid to ask. This is going to be a fun, interactive afternoon with personal, hands-on training by committee members, and will provide you with an even greater opportunity to refine your technology skills and receive one-on-one attention. Your spouses, friends, and other guests will also be invited to this program. It'll be set in the same room. We'll have great internet access. It'll be 4 hours long. You'll need to bring your own laptops and your iPads, and that day we'll spend a great deal of time not only hearing from some of the best minds in the country who will remain a surprise at this time, but some leading experts in technology will be speaking at this program. We'll also have hands-on help from our committee, and we hope that through this process, all the fellows will move into the 21st century adept with the knowledge and comfort of using social technology in your family law practices. So thank you for your attention. Watch out for the upcoming short videos, and I can't wait to see all of you in Chicago in November.